All rise. The Supreme Court of Guam South Session. The Honorable Robert J. Torres presiding.
Afternoon, good afternoon. You may be seated.
Okay.
Will the clerk please call the case?
This is Supreme Court case number CRA23-008, People of Guam Plaintiff Appellee versus Dwayne Richard Peters. Appearing for Plaintiff Appellee is Attorney Christine Tenorio. Appearing for Defendant Appellant is Attorney Joshua Walsh. The panel members consist of Chief Justice Robert J. Torres, Associate Justice F. Philip Carbolito, and Associate Justice Catherine A. Merriman. Your Honor, Attorney Walsh reserves 10 minutes.
You may proceed, Mr. Walsh.
Mr. Chief Justice, and may it please the court. Mr. Peters stands.
Can you hang on 1 second?
Of course, sir.
It's probably. Turn off your focus. Okay.
All right, go ahead and try it. Nope.
No, hang on.
Yes. I'm trying to get this stuff up. No, it was seven. Here we go. Well, this off. Yep, that's off. That's off. Test. Yep. Let me,
Is that negative?
yeah, it's on. Speak. Yeah, it's on.
Just give us 1 minute, please.
Test. Turn this down to.
Test. Good. You got it, Your Honor.
Sorry for the interruption. You may proceed now, Mr. Walsh.
Thank you, Mr. Chief Justice, and may it please the court. Mr. Peters, the appellant here, stands convicted in a case where his trial counsel undertook no pretrial effort to obtain relevant discovery that was probative to the allegations made against him. Mr. Peters was also convicted upon the testimony of his co-actor spouse, who was accused of participating in the abuse at the heart of this case, but was promised a plea agreement guaranteeing no jail time so long as she testified against her husband in conformance with what the government's clear expectations were about what she was going to say. Mr. Peters had ineffective trial counsel during the discovery phase of this case, and that ineffective assistance was compounded by the extraordinary plea afforded to his co-actor. The matter should be remanded for a new trial.
Can we address first the issue of standing? You didn't really get a chance to address that in your reply brief. The government raises the issue of standing to challenge the plea agreement as a third party, and that you don't have standing to challenge that plea agreement.
Yes, so I think most directly, Mr. Chief Justice, what I'd offer is the injury that we say occurred because of the plea agreement. So we do have an injury point here that so from my client's perspective, affects Mr. Peters's trial rights. I will also offer some distinguishing characteristics between the standing issues raised in the plea cases cited by the government and ours. The big difference is that they're not looking for the same analysis point. You have other individuals seeking to disrupt or dispute or interfere with a plea agreement that was entered by other parties they were not parties to. That is different than in this case, where a co-actor in what was an originally joint case is going to be offering testimony to the government in exchange for this plea. So I think that while traditionally somebody who's a stranger to a contract, and the plea agreement's a contract, would not have standing to disrupt that plea, that's different here, because ultimately what Mr. Peters is complaining about was testimony brought into his trial because of that plea agreement. So we think there's an injury that at least gives him a footing of standing.
Right now, in this case, you suggest the terms of the plea agreement required Mrs. Peters to testify under a compulsion, but it didn't compel her to conform to an earlier statement that she had given police, whether that was truthful or not. It didn't require her a conviction to be obtained. It only required her to testify truthfully. I thought, let me see the plea agreement. It said that she agreed to testify truthfully, and they agreed not to prosecute her for the crimes arising from the facts that were described in the police report. She didn't get an illegal sentence, did she? I mean, she received what she might have been able to obtain, at least the minimum sentence that was required. So why is there a problem with that plea agreement?
So I recognize, Mr. Chief Justice, that in the courts literally below this level, oftentimes these cases are moving along because of plea agreements and plea agreements that are entered against co-actors. I have no fault or no issue with the cases cited by the government about how we rely upon that. However, in this situation, Your Honor, I think that the fact scenario matches what we've cited to the court in Medina, and it's not just from the plea agreement. It's from the colloquy that the trial counsel or previous counsel did not attend to make an issue about. It's the lines appearing in our brief at page 13, at the excerpts of record at 39, where the government confirms to the trial court judge that we have a colloquy ready for what she expects to be able to testify to at trial. So like in Medina, at the time of this extraordinary plea agreement, remember, this is a sex assault on a woman's own child, her own blood child, that the government saw fit to give her a 0 jail time plea on. At that plea colloquy, the government avers that she knows what she's expected to testify to at trial. It was confirmed that Natasha was required to submit a written statement. So maybe not of the exact recorded testimony we have in Medina, but a written statement before the trial, and then to testify at the trial. And that Peters and the government had already examined her testimony, the testimony that would be offered eventually. That's excerpts of record at 40. So while I'm not standing here today raising an issue that the plea agreement was flawed in terms of the broad discretion that a trial court judge has in terms of applying the laws of Guam, that plea agreement of 0 jail time, coupled with the government's firm knowledge about what this woman was exactly going to testify to, and then the testimony that happens after that, I think places this case in a novel position before this court. It's a plea agreement that should not have occurred. And I think,
isn't the government normally going to know what the person is going to testify to or what they expect to? And if they don't testify to that, then they might have a provision in the plea agreement that they, won't get the benefit of it if they don't testify truthfully. I mean, I could understand if there was a requirement in the plea agreement that she had to testify in a particular way, whether it was truthful or not. But I thought that at least the plea agreement did not require her. I mean, I thought that there wasn't a provision that said, hey, you're going to perjure yourself or you're going to do testify consistent with the statement that you gave police earlier, whether that statement was true or not.
So I'm not offering that the government put forward testimony that it thought would be untrue. In fact, I think to the contrary, I have no reason to believe that the Attorney General's office, Mr. Brown in this case, or Ms. Tenorio, when they were prosecuting this, were trying to bring perjured testimony forward. Right. But the distinction that I'm raising for Mr. Peters.
Maybe I'm missing that distinction.
The distinction I'm trying to raise by raising this Medina situation is that the extraordinarily good nature of the plea to the defendant, Ms. Peters, the fact that she's going to have no jail time after admitting to sexually assaulting her daughter over a period of time, that coupled with what she tells the government she's going to testify to, and the government is certain she's going to testify to before entering into this plea agreement, which is doubled down and confirmed again during the colloquy at the trial court level, all, I think, places this case in a unique situation where the plea agreement that is being used here is improper, at least under the teachings of Medina.
But how is Mr. Peters harmed if the plea agreement requires, calls for Mrs. Peters's truthful testimony? I'm not understanding. I mean, I understand that she got a deal and he didn't, and he's apparently quite upset at that. But if she was required under plea agreement to cooperate fully and to testify truthfully, how is your client's rights to a fair trial compromise?
I understand it's a difficult argument to make because I assume the court's next question will be something along the lines of how we're able to cross-examine her at the trial about her truthfulness. But the appellant's perspective is that Ms. Peters testified untruthfully, but that he should never have been placed in the situation of having of that testimony coming forward, because that plea agreement should have never been accepted by a court to begin with. So I think these plea agreements always are going to say the defendant needs to testify. And even if it doesn't say the word truthfully, we are assuming that would be truthfully, because no government official or officer of the court would put forward an agreement seeking perjury. But if that is all that is required to keep a case out of Medina, then Medina stands for nothing, because there has to be some scenario where a trial court judge is allowed or trial counsel is obligated to raise these issues about plea agreements that are just too good, plea agreements that encourage or might encourage, or from Mr. Peters' perspective did, I suppose, at this trial, did encourage testimony that was not truthful because the deal was just too good. This was a hole that Mrs. Peters was going to run through so long, and the only reason she got this plea agreement is because the government knew exactly what she said she would testify to. So while I'm not saying the government's asking for untruthful testimony, all of these plea agreements always call for truthful testimony.
But wasn't Medina really because of the condition? It was error to condition the immunity that was given to the accomplished witnesses there on the requirement that they not change their testimony that they gave to the police officers earlier, and whether that testimony was true or not. And I thought that was the distinction in Medina. That was what made it it was error for the court to accept the plea when that immunity was said, look, whatever you testified to or provided in your statements, that's what you have to testify to at trial.
I think, though, as I offer in the reply, and I didn't mean to be curt about it, but that's a bit of the distinction without a purpose in the appellant's view, because the government knew exactly what the testimony was going to be in order to get that immunity. So while in Medina, you're right, Mr. Chief Justice, that there is this this immunity agreement, and nobody said you have to testify X or Y, but you have to stick to the testimony you gave earlier. That is the fact scenario that occurred here. The only reason that this witness was provided the immunity she was provided because, like in Medina, they knew what the testimony was going to be.
But I don't see anything in the plea agreement where it says you have to testify in accordance with the statements that you gave to the police earlier. Is that in this plea agreement? Did I miss it?
No, Your Honor. But that's why we offer the colloquy that occurred during the change in plea for Ms. Peters. That is part of the record, and part of that record has a judge very correctly asking, why this plea agreement? How are we doing this plea agreement? Actually, I think if the court looks at some of the decisions and orders of the record below, I think even Judge Martinez calls into question her credibility. However, the judge moves forward with this because the government provides these extra facts that appear in the record. That we know what she's going to testify to. She's got a written statement. So if those were included in the plea agreement, then I would say we fall even closer along the Medina line. But here, Mr. Chief Justice, we don't have that in the plea. You're correct, but we do have a record during a plea colloquy, which this court acknowledges is an important part of the plea and part of the record of what's being done. And I would think that counsel for the appellee would also agree that sometimes terms are shaped during these colloquies or these takings of the pleas that I think puts us in a situation like Medina where we know exactly what the testimony is going to be. And I think that also highlights the difficult second point we are raising, which is the trial counsel at the time undertook no effort to step in the way of that plea agreement or to do anything to attack that plea agreement or to raise the issue with the judge who the case was joined previously with. So there was no effort to do anything about that. The plea agreement was taken and then later a trial occurs. But there was no effort below from the trial counsel at this stage of the proceedings to do anything related to that plea agreement, including asserting issues like spousal privilege. I'm not saying we're appealing a spousal privilege issue, but none of those issues were raised with the trial court. And I think that's also indicative of the broader second point on our appeal, Mr. Chief Justice, which is the pretrial counsel was also my co-counsel during the trial. The record shows that did nothing to obtain what seemed to be available records that might have been probative to the nature of this case, these journals. And I think
Didn't you have a right to cross-examine on those journals? You asked for continuance, and so shouldn't we be looking at it under rather than as a Brady violation about the timing of the disclosure and whether it denied him a right to a fair trial?
Yes, sir. The difficult dance that I acknowledge that the appellant here has to do with those journals is convince this court that those journals not coming into evidence was still an error. We didn't have to cross-examine Mr. Chief Justice because ultimately the government did not bring those journals into evidence at the trial.
Yeah, but you did have them to be able to.
We did. We had an afternoon in court. I think my supplement to the record indicates that the way that process worked was Mr. Brown brought them to court. We spent some time looking through them and made an agreed decision with the prosecutor not to put them.
Was there any exculpatory information in there that could have been helpful to him? I mean, you didn't point to any.
You're right, Your Honor. So first of all, we don't have those journals. None of that entered it into the record as either evidence or potential evidence at trial. Once a decision was made not to bring those into trial, or we worked with the government not to bring those into trial, we move forward. What I can offer though, what I want to offer to this court on that point is trial was moving. Trial was afoot. We had a jury that was impaneled that we wanted to present the trial to. So as trial occurred, a decision had to be made by trial counsel. Are we going to pick a fight over having the government bring these in or just keep them all out? But in terms of reviewing them for exculpatory evidence, Mr. Chief Justice, that was not done in the afternoon that they were seen. It just physically could not be done. There were multiple volumes of these journals. But to that point, if there were exculpatory material, there was an obligation of the government to bring them forward, to give them to the defense. And that did not occur. What we learned later was that I suppose the government had informed the pretrial counsel that these journals were available at some point, but they were never inspected and no motion work or no work, pretrial discovery work was done to get them before the trial. What happened was trial started and they appeared and work of the attorneys, the defense lawyers to keep them out, I guess, occurred. That's why there was no cross-examination about the journals. But I cannot stand here and say that there was a full review of whether they were exculpatory or not. The government had the obligation to review them to see if they were exculpatory, and the government seems to have made a decision that they weren't. I will say, though, just on a common sense point, if you have multiple volumes of journals that cover multiple days, and not every day of those journals indicates a sex assault, then there perhaps is exculpatory evidence because, you know, Tuesday journal entry, no sex assault. There seems to be an incongruence there if you're keeping a journal, but there was no time for an analysis done on that. No analysis was done pre-trial. No effort was done to try to get those. And during the trial, the decision was made to work to just keep them out in total, so it wouldn't be raised in front of a jury that Mr. Peters wanted to move forward with.
You raised the sufficiency of evidence, at least in the beginning of your brief, but then there wasn't any discussion of that. And you didn't order any transcripts. Have you abandoned or forfeited that claim that the evidence was insufficient to support a judgment of conviction?
Without having reviewed the journals or the issue of the journals of the pre-trial discovery that was never taken, I don't know. I'm sorry. I acknowledge that the record is complete with not, and I'm sure counsel will point out, not just the testimony of the victim saying abuse occurred, but also the testimony of the mother saying that she participated in abuse that occurred because of the appellant.
Yeah, I mean, you raised it in your brief, but then you didn't discuss it. That's why I wondered. It was just there as a header, and I didn't know if
there's testimony on. There is testimony without Mrs. Peters that this occurred, and I think the court's precedent is clear that the testimony of a victim is sufficient evidence that could support a conviction. What I'm offering, what I'm asking is for the court to review. Perhaps there were other errors here that could have more effective assistance to Mr. Peters early on in this case may have changed that result, to change the contours of that trial.
I want to focus on the right to effective assistance, because you had brought up obviously some of the discovery errors or asserted errors that you said your co-counsel before you entered an appearance, Mr. Tecker, and whether apparently he did bring up some issues of the discovery during the pretrial conference of the journals, but you know, why he didn't do more before the trial in that regard. It doesn't seem that there's enough information for us to make that determination now. And I wonder whether that might be more appropriate for a habeas proceeding.
We'll be left with a habeas proceeding, Mr. Chief Justice, if the court does not provide the relief we seek. However, I do think that, and I think a process of remanding the matter, if the court was not inclined to remand the matter completely for a new trial, but remanding the matter for further proceedings on the nature of these journals and whether there really was something exculpatory that should have been tendered over in the first instance from the government, or something else that could have been more useful. The in-camera review, perhaps, which was discussed at some point in the record. I think Mr. Tecker had a discussion with Mr. O'Malley at one point about that. Yes, Your Honor, that does sound in habeas relief, but the ineffective nature of doing no pretrial discovery, I think on its own is enough to warrant Mr. Peters getting a new trial with new counsel.
All right, you have 10 minutes remaining. So
thank you. I will reserve the balance of my time to see if I can address any points that the appellee makes. Thank you, Mr. Chief Justice.
Thank you. Ms. Tenorio.
Mr. Chief Justice, and may it please the court. This is a case where a defendant belatedly tries to challenge his spouse, co-defendant's plea agreement, and tries to invalidate that and the testimony before this court, saying that it is coercive. The government is of the belief that they do not have standing to challenge the plea agreement. They do have standing to challenge the testimony. None of those were done by either trial counsel.
What if the plea agreement, like in Medina, conditioned the immunity on testifying consistent with the police statements, whether that was truthful or not? Or what if a plea agreement gave a defendant an illegal sentence and in exchange for testimony at trial? Do you think that he could have standing to challenge it then?
Yes, in those limited circumstances where your constitutional rights are going to be affronted just by the very nature of the plea, then you would have standing, because then you would be injured in fact. However, the plea agreement in this case specifically stated that
the cooperation was only to provide truthful testimony, not in conformance with any earlier statement that she had made. And the trial counsels, both of them, did have the discovery that Mrs. Peters gave a statement during to the police during her initial interview, and she never departed from that statement in both the subsequent interviews with the Attorney General's office. So we put them on notice that this was the testimony that would be coming forward, but we never conditioned the plea agreement on that testimony. This court has considered in People v. Pielet, where it was explained if the Attorney General doesn't set the parameters, extra parameters in a plea agreement, then the validity of the plea agreement is only analyzed by the four corners of the document. So when the appellant argues that you should take into consideration the colloquy and what that might have induced, I believe that that is inaccurate, because if you look at the colloquy, there was no exchange that stated the government would be expecting her to testify in a certain manner. What had happened was the trial court questioned the plea agreement, and then the trial court actually questioned whether we knew what she was going to say. And of course, based on her statements to the police, and then based on an impending interview, we had a general idea of what she was going to say, but we did not condition her lenient plea agreement on that. And in also People v. Pielet, this court had stated there is not error for a trial court to accept a lesser plea or a lesser sentence from a co-defendant. In this case, she was charged with complicity. So Mrs. Peters did not herself sexually assault the child. It was that she promoted or assisted Mr. Peters in doing so. And we did actually start a jury selection for Mrs. Peters, but then at the end of the day, she chose to cooperate in exchange for the lenient sentence. But that was not, the promised benefit was not that she had to help us obtain a conviction against Mr. Peters. It was just to testify truthfully. I do not believe that appellant's comparison with Medina is accurate. In Medina, the court specifically stated that because the plea agreement was conditioned on the testifying co-actor to testify in conformity with an earlier statement, that is the whole reason why the plea was invalid. And expanding on Medina and People v. Allen, the Supreme Court of California stated, as long as you require truthfulness of the testimony, then it is not coercive. But the trial counsel, they didn't attack the plea agreement and they didn't object below. There are there was some jurisdictions that I cited that said that's waived for appeal purposes. But if this court considers that a forfeiture, then it would be subject to plain error review. But because both Mr. Tucker and Mr. Walsh were available to object to any testimony coming from Mrs. Peters, and they did not, I believe that is waived on appeal. But for plain error, under the plain error standard of review, it was not error. The court did not plainly err in accepting the plea agreement because all that was required was for her to testify truthfully. And this court has upheld accomplice plea agreements. And in the body of law is you can accept a lenient plea agreement that calls for a lenient sentence as long as there are procedural safeguards in place to ensure that the testimony is not perjured. And that is the whole point of the plea agreement, so as not to coerce testimony. The focus is on whether it's going to be perjured or not. And in this case, of course, as prosecutors, we would never suborn perjury, but the trial court instructed the jurors on the, bias or credibility that you have to take into consideration any motives people might have any witnesses may have to lie. And so the jurors were able to hear that. They were able to hear that she was going to get no jail time if she testified. And they were also able to hear we were basically able to hear the parameters of her plea agreement. So although the appellant focuses on, well, the plea agreement is just too good and we have to find a way to be able to attack that, in this case, there are a lot of extenuating circumstances, and as long as the plea agreement is legal in nature, which it was, she pled to facilitation of the event that was underlying Mr. Peters' conviction, then those should be upheld as not being coercive. Now, as far as the ineffective assistance of counsel, I do believe that there is sufficient evidence in the record to address that issue on a direct appeal rather than habeas. So for the issue of the journals, I made sure to put on record at the trial court level that they were available for inspection at the Attorney General's office. Neither counsel came to the office to look at them, even though we actually provided a report saying we have the journals, they're available for inspection. But also, the people had never intended on using it as an exhibit.
How long before the trial actually started that was this notice provided to counsel?
So we provided the first notice that the journals were available for inspection, I believe in July of 2021. The trial did not occur till August of 2022. And although the prior trial counsel, they do have a duty to inspect, but the prior trial counsel was already trying to get out of the case. There were reasons, we had a chamber conference about it. There were reasons that he had needed to get off the case. And so although Mr. Walsh's firm did not enter appearance until 10 days before trial, Mr. Walsh had already been working with Mr. Tucker because they were appearing. Even though there was no formal entry of appearance, we were appearing for the hearings together. So yes, both of them had a duty to inspect, but there was no Brady violation because we had made them available for inspection under the discovery statute. And then even before trial, there were 3 prosecutors who combed through the journals. Of course, we understand that we have a duty to turn over exculpatory evidence, and there is nothing exculpatory in nature. When we did photocopy it, we only photocopied the journal entries where Mr. Peters' name appears, and that was the 2 journal entries in question. Those were not exculpatory, they were inculpatory, but even when we filed the exhibit list in 2021, when the case was first going to go to trial, the journals were never listed as exhibits because they were never meant to be entered into evidence because they're all hearsay. So this way the journals were not appearing. And so under the case law that I have cited, you do have a duty to inspect, especially if you know that it will be used against your client. But if you're not aware that it's going to be used against your client because you do not see it on an exhibit list, then that weighs against an ineffective assistance of counsel finding. But the focus of an ineffective assistance of counsel, it's actually if we can dispose it on the second prong, which is whether Mr. Peters suffered prejudice, then we don't even get to the analysis of counsel's performance. In this case, it cannot be said that Mr. Peters suffered prejudice because nobody used it at trial. The jurors didn't even know that it existed, and had the prosecution used it in trial, it would be inculpatory. So it actually lent and corroborated the victim's version of events as to the 2 days. Now, the appellant suggests that it's exculpatory if the journal entries don't reflect each day that she had been sexually assaulted. However, just by the nature of journals and upon inspection, you'll see that it's not what happened today. The journals are not talking about, dear diary, this is what happened today. It's what someone is generally going through in their life. And those journal entries said she had been raped by Mr. Peters and referenced some of those acts. So he did not suffer prejudice because nobody used it. And although the appellant states that they did not have sufficient time, I believe the record shows that the trial court asked if they had sufficient time. They took a recess so that you can review the journals. And I believe there were, I want to say 6. I'm not sure about the number, but there are 6 journals and they're short entries, but there was sufficient time, and counsel never indicated to the trial court that we need more time to inspect the journals. But at the end of the day, there was no exculpatory information inside those journals. And so under People v. Mateo, I don't think it is correct to remand in this case for a possibility of whether there's exculpatory evidence, even though it was available for inspection the whole entire time. We're not talking about the related discovery that was just turned over in the midst of trial. We brought it so that, you know, to give both the trial counsels the opportunity to inspect because they failed to inspect it at our office. And that's normally how evidence inspection works when we're bringing physical evidence to court. All the evidence goes to court the day of the trial, whether it's going to be used or not. That way everybody sees the physical evidence before it, and that's what happened. So the prosecution didn't use it, the defense didn't use it. Even after perusing it, they chose not to cross-examine. And when something is strategic, this court has stated if it's strategic on the part of the counsel, then that does not equal ineffective assistance of counsel. So clearly, there was some sort of strategy if the counsel elected not to cross-examine the witness on the lack of journal entries, as they have just argued here. The lack of journal entries could have been a question which was not used, so that is strategic. But at the end of the day, Mr. Peters suffered no prejudice because both trial counsels failed to come over to the Attorney General's office to inspect it. So this case is distinguishable from the Kimmelman case that appellant cites, because in that case, that defense attorney just didn't engage in pretrial discovery at all. They didn't ask for any discovery. And in this case, there were hundreds of pages of discovery, which both counsels did acknowledge receipt of. Now, and as far as the sufficiency of the evidence, I do think that that issue is waived because I believe it only was stated in the standards of review that there was not sufficient evidence. However, the appellant has the duty to order the transcript. But even by the limited transcripts that the appellant did order, SQ's testimony is there. And by SQ's very limited, the limited portion of the transcript that your honors can see, even by that transcript alone, there is sufficient evidence because she states the acts that occurred and when they occurred. And then Mrs. Peters comes to testify that at least one of those acts did occur in her presence. There was only one act that occurred in her presence. The other ones occurred not in her presence, but I don't believe that that is an issue for appeal because that's waived and your honors don't have the full transcript below it. But Mr. Walsh is right. The victim's testimony may not be corroborated, but here we did have the corroboration by way of Mrs. Peters' testimony. And there was other corroborative testimony, but again, we don't have the full trial transcript. So I believe that that issue is waived. The issue of the sufficiency of evidence. And I believe that that is the government's position on this. I just want to say though, if we go back to the being able to challenge your co-defendant's plea agreement, I believe that there are limited circumstances that you can challenge it, such as the circumstances that the Chief Justice has stated. However, if we were to have a rule where you can always challenge your co-defendant's plea agreement, then every person who is going non-testifying co-actor would have their plea agreements collaterally attacked by the defendants that are choosing to go to trial. So it is not enough to complain that one person's plea agreement should be attacked because it's a lesser sentence. That is not the purpose of you don't have a right to do that unless your rights to a fair trial will be affected. And in this case, Mr. Peters' right to a fair trial was not affected. He received a fair trial. Both trial counsels had all the discovery before them, and Mrs. Peters' testimony was not so coercive in nature or coercive in nature at all. And he wasn't convicted solely on Mrs. Peters' testimony. He was convicted primarily based on the victim's testimony, and then Mrs. Peters corroborated that. Thank you.
Thank you. Any further questions? We have no further questions. Mr. Walsh? You have 10 minutes left.
Thank you,
And 4
Mr. Chief
seconds.
Justice. The government suggested this is a belated effort to attack a taking of a plea agreement or to attack testimony that should have been objected to under the Medina standard when Mrs. Peters showed up at trial. That line of objection was not available to trial counsel at the time Mrs. Peters showed up to testify, because the pretrial counsel had done no work to understand or even be present for the nature of the plea agreement in the severed part from Mrs. Peters. So the issues of Medina, or the issues of what actually happened at that plea colloquy where the co-actor promises that she's going to make a written statement and give it to the government prior to the government bringing her up to testify, none of that is known by trial counsel at the time that Mrs. Peters is testifying. Excuse me. So I think that places this situation in a different situation than typical co-actor testimony, which I acknowledge is well accepted in this jurisdiction.
But Mr. Walsh, couldn't you have at least objected on the spousal privilege or other things at trial? Apparently there was no objection to any.
Right. So, yes, what I can tell you, Justice Merriman, is that my understanding of the trial at that time that Ms. Peters was going to testify is that that ship had sailed, on whether or not the spousal privilege would have been there, what you're going to testify to. I understood that ship to have sailed when the plea agreement was taken. The record colloquy shows there is a discussion, I think, between government counsel and the judge over these privilege issues. So when I came into the trial, I understood that issue to be done. But we did not know that there was no effort to deal with that during the severed portion of that. That's the part of the ineffective argument I'm making. We didn't realize that my co-counsel, we had done nothing in the early part of Mr. Peters' case when these testimonies will be offered to address that. And maybe perhaps if I could offer a few dates on a timeline, I think this could help the court, and I'm sure the court will review these timelines. But the indictment is in February 21 of 2020. The severance comes April of 2020. And Ms. Peters' plea agreement at excerpts of record 33 to 46 comes in January of 2021. There is a discovery cutoff date set by the trial court judge for February 11th, 2022. So these issues of the journals that are raised, or the questions about what journals that aren't used or investigated, all that needed to be done by February. And I think the issue of the trial testimony by Mrs. Peters should have been done when the plea agreement was going to be taken. But there is no objection on the record when Mrs. Peters gets up to testify about her conduct. There isn't, Justice Merriman, you're right about that on the record. There isn't an objection to that, or the fact that she's testifying as a spouse broadly, or to this plea agreement. But again, what I offer is that none of these issues related to how we suggest coercive her plea agreement were known to any counsel at the time. Counsel is correct that my office shows up to assist Mr. Tecker prior to the entry of our appearance, but the first time I'm in discussing this with Judge Barcinas is on May 18th, 2022, several months before our August trial date. And I haven't entered an appearance of discussing on the record about maybe working with Mr. Tecker to assist bringing this matter to trial. But my entry of appearance comes in August 3rd, 2022, just prior to the start of the trial. The fact that we were able to keep those journals out of trial, I understand causes difficulty, because then what's the harm, as the government suggests? How could there have been an error here? You kept all the inculpatory evidence out. I don't know that. But part of the reason I don't know that is because, and I'll just say it plainly, we had to make a trial decision with the jury we had and the odds that Mr. Peters was facing at that time. So a decision had to be made, and it's a strategic decision to keep those documents out, work, rather than pick a fight about getting them in at that time, because that's the way our trial was moving. However, and I will say this plainly, I had no idea that these journals hadn't been investigated or looked at all before. or that they had been made available to the prior counsel, and no efforts were made to obtain that in discovery. And Mr. Peters, I think, was ultimately prejudiced by the fact that his trial counsels, and I'll say me included, didn't have an effort to review that. Now, when I get into the case, I coming in post discovery cutoff, post what I think is documents we should have received. But Mr. Peters is going to prison, and his lawyers did nothing to do pretrial discovery to get these journals. And I am not saying that the only thing that convicted him are a lack of journals or his wife's testimony or his stepdaughter's testimony. However, I think the errors here, coupled with a plea agreement that the government knew exactly what was going to happen here with the testimony, that no trial counsel made an effort to fight either on privilege issues or anything else, militates toward finding that this matter should be remanded. Thank you, Mr. Chief Justice.
Thank you, Mr. Walsh. There being no further questions from the court will take the matter under advisement. We will issue a written opinion and will now stand adjourned.
All right.